Here's 8 things not to put in your will. So the first thing is having to do with end-of-life care. That would be living will provisions and the organ donation instructions. The important thing about that is that it happens before anyone looks at your will. If you pass away, there's a very short window in which to harvest your organs if that's something that would be permitted under the terms of your advanced medical directive. The other thing that you wouldn't want to put in your will having to do with medical wishes is end-of-life care. Again, no one's reading your will until after you're gone, so those medical wishes about when you would or wouldn't want to receive life-prolonging procedures in the event of a terminal condition should go in an advanced medical directive. And then you would also be giving someone authority to make decisions for you when you're incapable of making an informed decision. What can go in a will that feels similar to that is your burial wishes. Very commonly, you will see people choose where to be buried in their will and articulate their wishes in that regard. The next thing not to put in your will is your IRA and retirement account designations. Beneficiary designations override your will and trust. They will apply to the distribution of that asset. And your articulated wish in your will is not going to be honored, and you're going to have some very disappointed people if it's not the same person. So don't put it in your will. The nice thing that you can do for your family with regards to retirement accounts is that you can concentrate them all in one place. If you do it one time, everything to your trust, spouse first then trust if you have a spouse, is that everything is going to pass through one centralized person to the ultimate beneficiaries in a protected way. So that's a good place to think about doing a living trust versus a will. Similarly, another thing that can't go in your will is anything that is held in a trust. That's point number 4, and relatedly point number 5, assets held in an LLC. The logic is the same for both of these types of assets. If assets are held by a trust, then the trustee holds title on behalf of the beneficiaries, and the terms of the trust apply to that distribution. The will is not going to be effective towards that asset that's held in trust. Similarly, if an asset is held by an LLC, the managers of the LLC, which are appointed by the operating agreement, or maybe its members in many cases as well, the members or managers of the LLC will exercise control over that asset, and your will is not going to be effective towards that asset. And again, beneficiaries will be disappointed if you go ahead and do that. Here's some common sense advice. Don't explain why you're leaving someone out in your will. Don't air your dirty laundry in public is the way to think of that. If you are leaving a will as the dispositive document for the distribution of your estate, then that will is going to become public record. And so if you go ahead and articulate things that give people an insight into family dynamics, that's undignified for your family. It's like having a fight in public. If you do want to explain yourself as to why you made certain decisions, then the place to do that would be in an informal letter to your family, or even heck, a video to them. Lastly, life insurance and annuity designations, similarly to retirement account beneficiary designations, those are going to control and not your will. And so life insurance and annuity designations should not go in a will unless you are making the beneficiary of that life insurance policy your estate. And you can make a life insurance policy payable to an estate, but it's not typically done because it enhances the cost of administration. Again, I'll make the point, beneficiary designations tend not to be the best way to leave assets either. It tends to be better to leave all of your assets through one centralized method, which ideally is going to be a living trust, because the living trust is going to concentrate the authority in your desired trustees, and it's going to articulate your wishes for what happens in more remote inheritance scenarios. And that's why I call beneficiary designations brittle, because it's less knowable what is going to happen if one of the appointed beneficiaries under a beneficiary designation dies, whereas we know very well what's going to happen if a beneficiary dies in your will or trust. And so beneficiary designations are brittle because if someone dies, then it can defeat the whole purpose of the plan. because the terms of the beneficiary designation are going to be governed by your account user agreement with the financial custodian of that asset. All right, that's 8 things not to put in your will. This video does not create an attorney-client relationship between you and my law firm. If you do need any help, please reach out.